All right, so good afternoon, everyone. My name is Iman Freeman with Baltimore Action Legal Team. I want to thank Mariel from Maryland Legal Aid. She's here to teach us all things expungement. And it's our goal, hopefully, to not only do this one time, or hopefully we can do it again, but more importantly, start to expand capacity of attorneys and legal workers that can actually do this important work. I think time and time again, we hear from our partners, from our grassroots organizations and our community partners, that this is one of the most requested services. And so BALT is being very intentional between now and the end of this year to start expand capacity in this and other areas. So just really quickly, a few housekeeping rules. If you have a question, please use the Q&A function at the bottom of the screen. That way we can keep track of the questions and we can make sure all of your all your concerns are addressed. If you have not done so, please in the chat area, please put your name and your organization. And I think that's it, Mary. And I think we talked about taking questions at the end. If you just have a burning question and needs to be answered right now, definitely use the raise hand function. And without anything further, I'll turn it over to you.
Wonderful. Thank you so much. Hi, everyone. Thank you so much for attending this. My name is Mariel Shutinya, and I'm the supervising attorney for the Community Lawyering Initiative at Maryland Legal Aid. We do a lot of expungements. We've done thousands upon thousands of them. The year and a half before the pandemic hit. So when I started at Legal Aid in 2018, up until the pandemic hit, I had over 300 expungement clients. Now I'm at over 400. And we have about 7 attorneys that work on general civil issues, but mostly expungement. And we work in community spaces. So Maryland Legal Aid is a very large civil legal service provider in the state. And in community lawyering, what we do is we go into community spaces to make legal services more accessible to the community. So we do lawyer in the library, we do lawyer on the bus, lawyer in the laundromat, lawyer in any house of worship. We have medical legal partnerships. We work with job centers, things like that. Just kind of trying to make these civil legal services as accessible as possible. And one of the major things we see all the time is expungement. And so what I'm going to do in this presentation is I'm going to go over, I'm calling expungement 101, but hopefully just kind of a baseline of what expungement means, how it works in the state, the eligibility. It gets a little tricky. And all of those kind of little questions and little things that pop up that we see all the time just doing so much expungement work. After the PowerPoint, I will keep sharing my screen and show you how to fill out the petitions. Actually, there's a court form that you can fill out and provide a few more other materials for everyone. And at that point, I will be able to provide them, for you via email or something after this, because some of them are really useful. Some are little cheat sheets, flow charts, things like that that can just make this even easier. So with that, there's my email address. If you have absolutely any questions after this or at any time about expungements, again, we do them a lot. It is my absolute favorite thing to work on. I think they're so important. I did my clinical work in law school on expungements, and it's just something very near and dear to my heart, and it's something that I'm happy to talk about with anyone at any time. And at the end of this as well, I'll include, my contact information again in the last slide with my direct phone number and all of that. But so just to get started, I'm sure everyone here is kind of aware about what expungements are, but expungements, why expunge, what is it? So any arrest is public record in Maryland, even without a conviction. So I hear clients all the time say, oh, I don't have a record. Then I can, look it up online and I see if they do, they were found not guilty. But that still stays on your record unless you request the court to remove it. And these arrests, charges, convictions, they all appear on background checks, if you're getting your fingerprints done, public court records, Maryland Judiciary Case Search, which I'll talk more about. But in general, these records exist even if you weren't convicted, if you don't ask the court to remove them. And these can have major negative impacts on employment, housing applications, child custody, applying for professional licenses, applying for loans, school, whatever it might be. I am also a big proponent of, if it doesn't need to be on your record, it's allowed to come off. You should take it off, even if it's not causing any problems. I had a speeding time. You could see all of my information, my address, my height, my weight, all of that. And, it's not a great feeling to have all of your information out there, especially if you weren't convicted of something, or even if you were. So I am a big proponent of getting expungements done if you can, if it's eligible. I know everyone here working on them. This is amazing. We do a lot of community clinics as well. So I'd be happy to, if we could team up and do more expungements wherever people might need them. But, they're important to be done, and it's not very difficult process, but it is a little complicated. So I'm really happy to be able to talk about this, and, obviously at the end if you have any questions. But like I said, expungements are not automatic in Maryland. You must petition the court. You have to go through this, otherwise they're going to stay on there. So just for a little context, when we're talking about expungements, I'm only talking about Maryland law. Each state has completely different expungement laws, and there is no comprehensive federal expungement either. So when I'm talking about this, we're only talking about Maryland charges. We have clients all the time that have charges in North Carolina or Virginia, and we always have to send them to the legal aid organization in that state because it just is different from state to state. And I'm only talking about criminal charges because I get this a lot too. Someone wants their failure to pay rent or an eviction proceeding or a custody case or something that removed from the public record from case search. And I completely understand why someone would not want that information up there. But unfortunately, there is no statute around expungement of civil cases. So we're only talking about these criminal charges. And I will talk much more about this. But criminal also includes traffic entries, so a traffic citation when there's a possibility of incarceration. So there's something called minor traffic and then serious traffic, or incarcerable and non-incarcerable traffic. Non-incarcerable traffic, that minor traffic is what it sounds like. There's no possibility of going to jail, even if you're found guilty of it. So these are gonna be like running a stop sign, driving while on your phone, things like that. Those are what we call minor traffic. We just kind of ignore them. I'll talk more about that. But traffic that's technically criminal, so traffic where there's a possibility of incarceration, so a DUI, leaving the scene of an accident, driving without a license, things like that. Those, we're gonna call them criminal traffic, and those may be eligible for expungement. So I'll talk more about that. But just so you know, it's criminal charges and then kind of more serious traffic. This does not include protective or peace orders. You can see those online as part of a court record. Again, that is a civil proceeding, even though there are some criminal implications. So that is not subject to the expungement laws in Maryland, but there is a shielding option. So, I'd be happy if anyone, has questions about this. This is available online. It's a court form. And I could talk more about that. We don't handle those, but we do, provide that information. And the big thing to keep in mind for this entire presentation and anything about expungements is going to be the statutes and the laws around expungements are almost always concerned with the disposition of the case. So it doesn't usually matter what the charge was, it matters what happened. So when I say disposition, I mean not guilty, dismissed, things like that. So if you could be charged with murder 1, and if it's found not guilty, it doesn't matter what that charge was. It just matters what the disposition was. It gets a little complicated when we get to guilties, but normally this is what we'll be dealing with. All right, so very quickly, the controlling law for this is all in Maryland Criminal Procedure 10-101 through 10-111. Absolutely everything. I encourage everyone to read these. It can sound a little boring to read the expungement law, but they're very short. I mean, it's like 10 pages altogether. It's very brief and it's very clear. Expungements are an administrative matter, basically. And so there are complications, and I will talk about that aren't part of the statute, but it's a pretty easy read. It's pretty clearly written, and it really can help clarify some things. And I'm happy to provide the text of that as well if people need it. And then there is not a lot of case law around expungement. I always joke it's because if we're successful in the expungement, the case is expunged and you don't really want any record of it. And it's just not a highly litigated issue. So the two really big cases are going to be Robert B. v. State, the citation's right there, deals with pending case issues and violations of probation. But it really is kind of the main case. We refer to it all the time, and really not very much else. We also have In re Dion W, and there's a citation. This is about partial expungements. Again, I will explain what that means. We just got this. This is a legal aid case. And it was, pretty exciting. But again, there's not a lot of, case law around this. So you're really always going to be looking at Maryland Criminal Procedure 10101 through 10111. So again, before I get too deep into it, this is a really important, very frustrating portion of the law, something called the unit rule. I believe it's in 10107. A unit consists of two or more charges other than minor traffic arising from the same incident. So like I said, we just ignore minor traffic. And if any charge in the unit is not expungible, the entire unit isn't, so that entire case. So a good example of this would be, you were charged with possession of cocaine and some, and theft at the same time, whatever happened. So you're found not guilty of the cocaine possession, but you're found guilty of the theft. They happened in the same incident. When you were arrested, you were charged with both of those at the same time from the same incident. If one of those isn't eligible, that guilty, the theft guilty, isn't eligible to come off, none of them, neither charge will. So the whole case stays. So there isn't a lot of partial expungement. It's only when there's minor traffic does that kind of happen. But in general, the unit rule is very frustrating because a lot of times people are overcharged and there's 3-4 charges and you end up pleading down or being convicted of, kind of the lowest one, but all of those other ones will stay. So you could have murder 1, not guilty, murder 2, not guilty, theft over $100, guilty. That whole thing's going to stay unless that theft charge becomes eligible. So this is just important to keep in mind right off the bat because it's very frustrating, but it kind of informs how you look at expungements. You want to look at the worst disposition, the most serious. So if there's a conviction, you want to look at that to kind of determine eligibility. And then very quickly on this minor traffic cases, again, I'm sorry, these are kind of these points that just need to be said before we can really get into it. Like I said, minor traffic or non-incarcerable traffic, they're not eligible for expungement under the statute because they're not really criminal. They're basically these administrative matters. So in that case, again, we ignore them. They're not going to be part of the unit rule. So if you had a guilty for running a stop sign and, at the same time you had a not guilty for a DUI or a theft or whatever from the same incident, it doesn't matter that you were found guilty of that minor traffic. We just completely ignore it. It's not going to affect the unit rule. The only traffic cases that are serious or incarcerable criminal are going to come up under this expungement statute. They may or may not be eligible. Like I said, just ignore minor traffic. One of the issues here is the court gets confused about this. The state's attorneys get confused about it. So the unit rule and this partial expungement, they can get a little tricky. So I'm happy if anyone has questions after this or if you end up doing expungements, this comes up. But generally, just ignore your minor traffic. And I will provide everyone with a list of incarcerable serious traffic cases so you know what those are. We'll give a little cheat sheet for it. You don't need to know exactly which ones. There is a list, so you can just reference that very quickly. And in general, if you have a client or someone you know or whoever is having the expungement done has a minor traffic case, those are going to be automatically purged from case search, from your driving record, anything like that after a certain period of time. Kind of this automatic expungement for minor traffic. There's a very detailed kind of table how they determine how long it'll be on there, usually about 3 years, but they do take into account your driving history and things like that. You can always go to the MVA website for more information, but most people aren't usually hung up on having a speeding ticket or something like that. But again, for the incarcerable serious traffic, I have a cheat sheet and I'll provide that to everyone. So you don't have to go, reading through statutes, always trying to find what's incarcerable and what's not. So the big thing with expungements is that both the case and the person needs to be eligible for expungement. So I'm going to talk all about when a case is eligible, what charges are eligible, what dispositions are eligible, that kind of thing. But the big thing that we see a lot is that the person themselves needs to be eligible for expungement. And what that means is that they cannot have an open criminal case. So no pending cases. So if you have an active charge against you and no disposition's been entered, you're waiting on your hearing date, your trial date, whatever it is, you can't file for expungement for anything. Even if the other charge you went off your records 30 years ago, it doesn't matter. It's just the way the law is written. It's very frustrating. It's antiquated. They just didn't fix it. But either way, we're bound by that. So the person can't have an open, pending, active case to have any expungements done. Being on probation is not a pending case. A disposition's been entered. There was a final verdict. Even if you're still dealing with your sentence, that's fine. You just need a final verdict, the disposition entered in the case. See, sometimes the specialty courts, the drug court is the one we see the most, where it'll say active because that person is kind of like a probation. They're dealing with the specialty court, the drug court, but the case, it doesn't get a final disposition. In those cases, even though technically it looks active and open, you can still file for expungement on other cases. So that one gets a little trickier. So you really just have to ask the person, what's going on in that case. And it's usually pretty obvious. It'll say drug court or whatever it is to show that this is a specialty court. It's a mitigating circumstance, and that doesn't count as an open case technically. And even active incarcerable, active serious traffic counts as a pending case. So if you had a driving without a license, that's technically incarcerable. That counts as an open criminal case. But if you have an unpaid ticket for running a stop sign or making an illegal U-turn, that's not going to hold up your expungements. Like I said, we just kind of completely ignore those minor traffic cases. They just shouldn't be affecting anything. Sometimes the courts again get confused by that, and we can follow up on how to deal with that. But generally, just ignore minor traffic. And if you filed for expungement or you signed the paperwork and you're about to file it, and you pick up a new case, or the client picks up a new case, whatever it is, that person then becomes ineligible for expungement until that's dealt with. So if you're in the middle of the process, the expungement hasn't been ordered yet by the court, you may need to withdraw, but you can always refile. They're always dismissed without prejudice. So, once that open case is closed out, there's a disposition entered, you are able to, at that point, file for those other cases. But it can be very frustrating, and you really do have to kind of keep checking to make sure someone hasn't picked up something new. So when we talk about expungements, one of the main things is you have to find all the cases that you want expunged, and you have to find all of this particular information so you can fill out the paperwork for the court. You can't just send them the case number and say, please expunge this. There's this whole list of information that you need to provide to them in order for the court to process it. So again, after this PowerPoint, I'm going to do a demonstration and show you how to fill those out. It is a court form that is fillable, a fillable PDF. It seems a little boring that I'm going to go through it, but so many people don't read it and then fill it out wrong, and their petitions get bounced back. So we'll go over that. But the main thing that we used to use was the Maryland Judiciary Case Search. It's that online case system, if anyone's ever seen it. I'm going to just have all cases unless you would ask for them to be expunged. And it had all the information you needed. So earlier this year, a new shielding law was enacted, and it's really great for a lot of people. Anything that's not a guilty, or what we call the favorable disposition. So you got a not guilty, or they declined to prosecute, or whatever it might be. Those don't show up on case search anymore. So, but they will still show up on a background check, or they're still public record. They haven't actually been expunged. So the issue now is that we can't see them on case search because they're shielded, which is wonderful, but that means it makes it much harder to then do the expungement petitions and get them completed. So that's making everything a little bit more complicated. So there are other ways to get the information, but unfortunately none of them are perfect. So one of the other ways is to get fingerprints done, and this would be at the Criminal Justice Information System, CJIS, called a CJIS report. This is, you'll get your fingerprints done, and then they will send you a list of all the cases that relate to that fingerprint. So traffic cases, or maybe other types of cases where you weren't fingerprinted, you weren't booked that way, probably won't show up on there. The list that CJIS gives you doesn't have all the information you need, so it's more of a starting point. You can find out that information, you might have to call the court or look through other ways. But but it is a pretty clear list of what's going on. There are two big barriers with these fingerprint records. One is the cost. It's about $38 to have it done. At legal aid, we usually get everyone's fees waived, court fees, attorney's fees, all that stuff. It should be free, but this is not something that we can have waived. So one, you have to physically go over there, take the time off work or get childcare, whatever it might be, physically get yourself over there, pay the $38 and then wait to get the paperwork. And so that can be a barrier for a lot of people. And then one of the other things is when you get your CJIS report done, it is a criminal justice agency you go to. So if you have an open warrant or an arrest warrant or anything like that, you can be arrested getting this done. So we always like to say, you know, if you have something like that going on, maybe this isn't going to be the best route. That being said, if you have an open warrant, you're not eligible for expungement at the moment anyway. But either way, I like to put that out there because I don't want anyone showing up somewhere and, you know, possibly be arrested. Right now, we've also been using Lexis and Westlaw public record searches. If you have access to that and that feature, you can download someone's record that's available on there, kind of combs public record searches. Again, this isn't always complete. So we basically use all of them and then make a chart and try to figure out what's going on with someone's record. If someone has their records from the court, their court paperwork, you can always use that as well. That's usually the best way. And that's what I usually see when someone only had one thing on their record. It was pretty recent, that kind of thing. But if people have longer records or records that are older, you know, going directly to the court and getting that information might be more complicated. So unfortunately, now that there's the new shielding laws for case search, it is a little difficult to get all of this information. But that being said, it is really helpful to a lot of people because one of the major things that, you know, why people wanted expungements was because this was on case search and it was just so publicly available. And it's not really bothering them because they're not having fingerprint checks done. So a little give and take, but obviously we're very happy that they were removing some of this from public information. I see someone just asked, is shielding just the public view? Can the client call the clerk for the info? Yeah, so for shielding, it's going to be hidden from public view. If you're a party to the case or something like that, you'd be able to see it. But so when I call it shielding with the case search, it's not the same as if you asked for shielding. It's more it's removed from the public record view, but it's still available from the court and fingerprints and all these other things. And if you use MDEC, which is the online filing system and online record system for the state, you can see it on there too. It's not hidden from MDEC. The issue with MDEC is that not every jurisdiction uses electronic filing. Not every jurisdiction's on there. So Baltimore City, Prince George's County, and Montgomery County are only paper file jurisdictions. They do not allow for electronic filing. They're not part of MDEC right now, so you can't see it on there. It's the three largest jurisdictions, so it gets a little tricky. But so unfortunately, you kind of have to cobble together expungements right now and cobble together the information in order to complete all the paperwork. Okay, so getting into kind of what's eligible, what's not. When we talk about dispositions, these are the things I'm talking about. So it could be a null pros. This could be, you know, you're arrested, you're charged, you go to a hearing, the state's attorney declines to prosecute. That would be a null pros. You get an NP, a null pros on your record. An acquittal, not guilty, you know, you were found not guilty. It was dismissed outright. A stat is kind of like a null pros. A stat is an indefinite postponement, is what I like to call it. It's the state is declining to prosecute at that moment. With a stat, it can be reopened and that case can be litigated within a year for no reason. They can just do it. And then for 2 more years, so 3 years total, they can reopen the case with good cause. Another type of disposition is a probation before judgment. This is typically when someone pleads guilty, and then in lieu of having a guilty on their record, they receive probation. And if they complete their probation satisfactorily, it will remain a PBJ and possibly be eligible for expungement at that point. It's a very common one as well. Less common are going to be your not criminally responsible and compromises. They are included in the statute. Honestly, I've never seen either of them, and Like I said, I've had over 400 expungement clients. I don't think any of us have seen that. They're just not common. If you have that issue though, it is covered in the statute, or feel free to reach out because we might be able to help with it. Transfers are when it's moved to a different court. The time that would be an eligible issue would be if someone was charged in adult court and then the case was transferred back down to juvenile court. That juvenile record is not eligible for expungement under this because it's already shielded. We're only dealing with adult cases. But that record, the charging record and that case record is still out there saying that, when it was charged in adult court. So because of that, you can have those transfers removed as well to kind of hide that. And then guilty. If you're convicted, sometimes that can be expunged, sometimes it can't. And I'm going to get all into what all of that means and what is not eligible. So I'm going to call these the favorable dispositions. These are things that are eligible immediately. This would be your null process, so the state declined to prosecute, acquittals or not guilty, dismissals, and then arrest without charge. If you were arrested and not charged by the state, so you were just released, if that happened after October 1st, 2007, no one needs to do anything. It's automatic. After 60 days, it is just expunged, purged from the police record. For these other ones, if you have one of these favorable dispositions, you can file immediately to have the case expunged. If you're filing within 3 years of the disposition date, at this point, you do have to sign something called a general waiver and release. What this says is that the court will look at your case and potentially expunge it immediately, but you have to waive your right to sue the police department, the state's attorney's office, anyone kind of involved in the case. I used to think this was incredibly shady, and obviously anytime you have to waive your right to do something, it raises some red flags. In this case, the reason they do it is because there's a 3-year statute of limitations to bring this type of case. The state doesn't want to expunge a record and then have someone sue them, and then they don't have access really to that record anymore to defend themselves. So obviously, sometimes people are contemplating a lawsuit and they don't want to sign this. Majority of times, people are completely fine signing it. I have seen someone get a null pros in criminal court, literally walk downstairs and hand in the paperwork, immediately and start to file for expungement. And then there's a couple of these, the stats and probation before judgments have slightly different rules. So with the stat, like I said, the state can technically reopen this and litigate this charge for 3 years. So because of it, a stat has a hard 3-year waiting period. You cannot file early. You can't waive away any rights on that one. It's just you have to wait the 3 years. Technically, you can file something called a good cause motion where you say that 3 years is too long and I have a lot of really good reasons why it should be expunged early. We help with those sometimes. They don't usually go well. And it's kind of hard to judge when it will or will not because it really just depends on what judge is listening to it. But if you have someone who has really compelling case and that really needs to come off early, it is technically possible. And that probation before judgment, this also has a 3-year waiting period from the disposition date. So it's 3 years from the date you got it. Same with a stat. So probation or judgment is 3 years from when you receive the disposition or the completion of the probation, whichever one is longer. So for most people, that's going to be 3 years. But because if you had a 1-year probation on your probation before judgment, you have to wait that full 3 years and then you can file it. But if you received a 5-year probation before judgment, you have to wait for the probation to be over before they can expunge it. I've only seen that once. The majority of them are less than 3 years. So normally you just keep it as it's a 3-year waiting period from when the PBJ was entered, the disposition was entered. There are a couple of caveats to this one though. You cannot have something called a subsequent conviction in the waiting period. Say it's a 3-year waiting period, and in that time period, you're charged with another crime and you're convicted of it. You're found guilty. In that case, the PBJ cannot be expunged unless that guilty becomes eligible for expungement. And I'll get more into this when we talk about when guilties can come off, but this can be very frustrating. So for probation before judgment, you can't have any convictions in your waiting period. You can have other charges, you could have null process, you could have another PBJ. That's okay. That's not going to lock it in, but a conviction will. And then the other caveat with PBJs is that a DWI or a DUI, probation before judgment, is never eligible for expungement. This is the only, like I said, it's all about your disposition, not about the charge. It doesn't really matter what you were charged with. It just matters what the final disposition was. In this case, though, for a DWI or a DUI, that is not allowed to be expunged if you received a probation before judgment or a guilty. This is the only one, though, but it's important to note. So eligible convictions. So this is where it gets different. Like I said before, all of those favorable dispositions or non-convictions, it didn't matter what your charge was. A null pros for first-degree murder is going to be treated the same way by the court as a null pros for driving without a license. It's all about the disposition. When we get to convictions, though, guilties, we have to look at what the underlying crime was, what the charge was, and that's going to determine if it's going to be eligible for expungement or not, and which one of these categories it falls into. There's about 5 categories of convictions that you need to know about. The first is something called nuisance crimes, and I'm going to go into detail on all of these and what it all means. But nuisance crimes are kind of very minor crimes. Marijuana possession and paraphernalia, there are new and different laws around this with the legalization of medical marijuana and other things like that. They are changing, it has specific laws about expungement of those. They're much more lenient than other drug convictions. Charges that are no longer crimes. So if you were convicted of something that's no longer a crime in the state of Maryland, that's going to be eligible for expungement. And then misdemeanors and felonies. Not every misdemeanor, not every felony is potentially eligible. The legislature wrote out a list of the types, the specific charges that can and cannot come off. And there's not a lot of rhyme or reason to which ones they picked. But I'll go into that more. But so it really depends on what the charge was when we're talking about a conviction. So nuisance crimes. This is going to be the easiest one. This is explained in Criminal Procedure 10105. Nuisance crimes, like I said, are these really minor crimes. You usually get a citation for them. So things like urinating in a public place, any MTA citations, so riding a transit vehicle without paying the fare, panhandling, sleeping in parks, vagrancy, loitering, drinking alcohol in public, obstructing free passage, sleeping in public, things like that. And then again, any of those mass transit citations. These are nuisance crimes. They're very minor. And for all of these, you have to wait 3 years from the disposition. So it's kind of like a stat. It's just a hard 3-year waiting period. And in these cases, there's no subsequent conviction rule. You could have 20 guilties in that 3-year period. It doesn't matter. These nuisance crimes only stay on your record for 3 years. You're allowed to petition the court to have them expunged immediately, or not immediately, after the 3 years. And at that point, it's just eligible. It doesn't really matter what happened in that waiting period. So marijuana convictions. This one gets a little trickier, but generally it's pretty easy to follow. Possession of marijuana less than 10 grams. If someone has a guilty for that, that's no longer a crime in the state of Maryland. Possession of marijuana less than 10 grams, you receive a civil citation, a payable fine. So if you were ever found guilty of that when it was criminal, that's eligible for expungement immediately. No, it doesn't matter if you had subsequent convictions, it doesn't matter how long ago it was. Usually it's been a while because that has been decriminalized for a while, but either way, if it says specifically charged with possession of marijuana less than 10 grams, you can file immediately. So just general possession of marijuana, more than 10 grams, but less than a distribution level. So really any personal amount, that is eligible for expungement after 4 years. No subsequent conviction rule, just a hard 4-year waiting period. So usually that's right now, most people, we're not seeing too many people getting charged or found guilty of this crime in the last 4 years anyway. It isn't being prosecuted as much. So normally you're pretty close to the 4 years if you haven't hit it yet. Paraphernalia, if you were charged with possession of marijuana and paraphernalia to use it, as long as it was associated with personal use, like that personal amount, that is eligible as well with this 4-year period. But any type of distribution charge or possession with intent to distribute, those are technically felonies, and those are not eligible for expungement under this specific thing. It might be eligible when we talk about felonies, but when we're talking about marijuana convictions being eligible for expungement after 4 years or for the less than 10 grams immediately, in those cases, it has to just be the personal use. So misdemeanor convictions. This is really actually very exciting, even though it's still very limited. So up until 2017, no convictions were eligible for expungement except the ones I just talked about. So just those nuisance crimes and crimes that are no longer crimes. So in 2017, they enacted the Justice Reinvestment Act. And what this did was it listed out about 100 misdemeanors, very specific, listed them out by statute that could be eligible for expungement eventually. For the misdemeanors, you generally can file after 10 years. Now, on those other ones, it was all about, 3 years. The waiting period started when the disposition was received, then you'd wait your 3 years for whatever it is. With misdemeanor convictions listed in here, and this is going to be under Maryland Criminal Procedure 10110, you have to wait a full 10 years from the end of the sentence date. So if you were on probation when the probation ended, if you were incarcerated and got out and didn't have probation after that, it's whenever the state is no longer punishing you and is no longer has any control over you over this case. So for some people, this could be a lot longer. If you had a 5-10-year sentence, you're going to have to wait, but it's always the end of the sentence date. And we would call it the clock starts running when your sentence ends, and then you have to go your full 10 years. Like probation before judgments, you cannot have subsequent convictions. So if you have any guilties in that 10-year waiting period, this case would not be eligible for expungement unless that subsequent conviction becomes eligible too. So it's all when this clock starts running. So I would say get a misdemeanor for theft under $100 in 2010, no sentence, it's just 2010. That's when sentence is over then. You have to wait that full 10 years, but in 2012, you received another guilty for theft under $100. You have to wait until that second one is eligible for expungement. At that point, let's say it's 2022, you waited the 10 years on that one, then you can file both of them off. So with subsequent convictions, you have to usually wait until the last conviction is eligible, and then all your guilties can be filed off if they're one of the misdemeanors listed. So that sounds a little tricky, and I'm going to go over that more. Again, I'm going to provide everyone with a list of all of the misdemeanors that are eligible for expungement after these waiting periods. I have a little flow chart that you can just kind of follow. They can make this easier too. But generally, it's when your last conviction becomes eligible, then your others might. And this can be very frustrating though, when you have a couple convictions that would have been eligible, and then you have a subsequent conviction for a crime that is not listed, and then everything gets locked in, and that's very frustrating. The big exception when I talk about this 10-year waiting period though, is second-degree assault, common law battery, and certain domestic crimes, usually all kind of a second-degree assault level crime here. You have to wait a 15-year waiting period for that. These are the only misdemeanors that have a 15-year waiting period. All the others have 10. But I would say second-degree assault is one that is a pretty common charge we see very often. So it's a good one to note that that has a 15-year waiting period from the end of the sentence date. So for felony convictions, way less are eligible. So like I said, there's about 100 misdemeanors that the legislature specifically listed out that can be eligible for expungement after this waiting period. They only have 3 felonies that they listed. And these are going to be theft, felony theft, possession with intent to distribute. Like when we talked about the marijuana, this could be possession with intent to distribute marijuana or any other drug, it does not matter. But it can't be possession with manufacturing, actual distribution charges. It's a very specific one. And then burglary 1, 2, and 3. They finally fixed this year, but I always use this as an example to explain how kind of odd the expungement laws are. Because it's just what they listed out. And I always joke, it's like the legislature has just put a list of like what their friends have been charged with that they wanted to be expunged, because there's not a lot of rhyme or reason to it. There's common ones like prostitution, theft, drug possession, things like that. There's also, like lying about a horse's name for a racing competition. There's very like obscure things we have in here. But so for burglary, they listed burglary 1, 2, and 3 as eligible for expungement, but they forgot to put burglary 4 in. Burglary 4 is the least serious. It's basically having burglar's tools in your possession or something. They forgot to include that explicitly in the statute. And because of that, a lot of times courts were denying people's requests to have their 4th-degree burglary convictions expunged. You could have 1st degree, the most serious one, expunged, but not 4th degree because it wasn't listed in the statute. Took a long time. They finally included it in there, but it just kind of shows you sometimes there was legislative oversight or just mistakes that were made that caused some issues. So it's really good to fully go through all of the charges and crimes that are eligible specifically in the statute. And for these felony convictions, it's going to be that 15-year waiting period, similar to 2nd-degree assault, and again, no subsequent convictions. The only way you can have these expunged is if the subsequent convictions themselves become eligible as well. So these waiting periods, this is just a quick summary of everything I just talked about, but they're very important. So there's no waiting period for those favorable dispositions or marijuana possession less than 10 grams. Again, if you want to file this within 3 years of the disposition date, you need to sign that waiver and release saying that you're not going to sue the complainant, the police department, the state's attorney, anyone involved with this. Then you have that 3-year waiting period for STETs, nuisance crimes, and probation before judgments. STETs and nuisance crimes, again, have no subsequent conviction rule. It doesn't matter what happened in that waiting period, you just have to wait it. The probation before judgments, though, you are going to have some issues if you have a conviction in that time period. You're going to have to wait for that conviction to become eligible before that PBJ can come off. There's that 4-year waiting period for marijuana possession over 10 grams, but less than a distribution amount. Again, in those cases, there is no subsequent conviction rule. It is eligible after you hit the 4 years. Then there's a 10-year waiting period from the end of the sentence for misdemeanor convictions, and then 15-year waiting period from the end of the sentence for those 3 felonies, the 2nd-degree assault. And then again, keep reiterating it, but it's one of the things that can be trickiest with expungements is if your subsequent conviction within the time period is eligible as well, the clock gets reset until that disposition, that subsequent conviction becomes eligible. And if your subsequent conviction in the waiting period is not an eligible charge, it's not one of the ones listed, then neither case is going to be able to come off your record. Very frustrating. We are very much hoping that they change the law. So instead of having all these listed ones out, it'll just say, all misdemeanors have X waiting period, all felonies have X waiting period. Because right now it's very confusing and not particularly fair because it seems very arbitrary which ones they've picked. So I put this out there because it helps sometimes if you're talking to clients or for yourself or whoever it is who's looking for expungements, if their cases aren't eligible right now or don't appear that they're ever going to become eligible. So like I said, the expungement laws have changed dramatically since 2017. Until then, only those nuisance crimes and things that aren't criminal anymore were able to be expunged if you were convicted. There are all these other rules around those favorable dispositions as well. But now there's over 100 different convictions that are eligible for expungement, even though you do have to wait a while. So, and as we've been noticing, is each year the expungement law gets broader and broader. It's not getting stricter. So there is hope that these things could change. I always encourage people to reach back out to us or Google it to see if new laws have gone into effect. It's usually July or October that this happens. You can look it up online or on the legislative website, or anyone could always call over to legal aid or the CLI or just me because we keep very up to date on these. We testify usually on these issues, so we know if the law had changed. And then pardons, we don't do these. We provide pardon packets if people really want to. It's when the governor can grant a pardon. This is not very likely. Don't particularly encourage people to do those because it is a very lengthy, intense process with very little chance of actually being granted. But with pardons, the really important thing to remember, and so many people don't know this, is that if you did successfully receive a pardon from the governor, you still have to request for the court expunge the record. And when we go over the petition that you fill out, one of the options is like, this was pardoned, now I want it expunged. I've only had one client who received a pardon, and she did not know that she still had to ask for it to be expunged. So she thought this was gone from her record because she had gotten a pardon from Governor O'Malley, but it was still there. And we had to file the paperwork on it. So a little oddity in there. So that's how the eligibility works. That's basically it. But there's a whole process after it that's going to be time consuming. It's not that you file the paperwork with the court and then it's just taken off your record if it's eligible. So you complete a petition for expungement. I'm going to call them court form A or B. A is going to be for your non-convictions, and these are free to file. And then court form B is going to be for your convictions, and these do have a filing fee. If someone uses legal aid for this service, we get those filing fees waived. The public defender's office has them waived, and any Maryland Legal Service Corporation entity that receives funding from MLSC gets it waived as well. I think it's $30, but again, that's only for convictions. So once the paperwork's filed with the court, the state's attorney's office has a 30-day period to object. This is written into the statute. There's a 30-day waiting period. And if it's a conviction, and there is a victim, that victim has this 30-day period to object as well. If no one objects, the court's supposed to just enter an order for expungement. You don't need to go to a hearing. There's really no follow-up. It just, the 30 days have been weeded out. Eventually, a judge will sign off on the order. It'll get sent to you in the mail, your attorney or you, or hopefully both. Now, I do have to say that this doesn't always happen, and it's very frustrating. Some courts like to judge set in hearings. So the state didn't object, a victim didn't object, but the court, for whatever reason, wants a hearing. I disagree that that should be allowed. The statute is quite clear. It says shall order. But when a judge sets a hearing in on one of these, there's not much to do except go to the hearing, unfortunately. But if an objection is filed, the court has to hold a hearing. So that's when you go and you can argue your points. We do a lot of these. The majority of time, cases just go through. If you filed for some null process from 10 years ago to be taken off your record, there's really probably no reason anyone's going to object, because objections really can only be based on this administrative capacity. It's not, well, that was a null process for a murder, and that's not a good idea. That's not how it goes. It has to be that the null process itself is not eligible. So if it fit the rules that we just talked about, it was eligible under criminal procedure and what we talked about, no one's going to object. Now, if the waiver is missing, they might object in that case, or sometimes we file for a PBJ off, but we weren't able to see that there was a unit rule issue, and there was a case that makes it ineligible, a charge that makes it ineligible, or whatever it might be. So there are times they object. I would say most of the times the objections are invalid and we win in court, but either way, either it's just signed off on by the judge, no one objects, you get an order in the mail, you don't have to do anything else, or a hearing's held. I'm not going to go too much into hearings here, but I would say if anyone's doing expungements and has questions, has a hearing set in, please feel free to reach out at any time. Again, I'll include my contact information. They're usually pretty informal hearings, but you never know. And I think I say it in here later, but you always want to file in the highest court. So that's right, I just didn't read it. File petition with the highest court the case is heard in. So case is entered in district court, a jury trial is requested, and it goes to circuit court, and that final disposition is entered by the circuit court. You're going to file the petition with the circuit court, not the district court. If it was appealed, even higher than that, you file there. It's whatever the highest court is that heard it. This can get a little confusing if something's appealed, no decisions given there, and it gets pushed back down to the lower court. Sometimes we'll just file in both, because depending on the court, the jurisdiction, it's they have different ways of interpreting this. And this is something really important to keep in mind with expungements, it seems like this isn't very complicated. You're just reading the statute and, making sure you're following it correctly. But we get these, different jurisdictions read things differently, think about things differently. And so sometimes you're not quite sure how they're going to rule on it, and you kind of have to know the intricacies and the idiosyncrasies of each jurisdiction, each state's attorney, that kind of thing. But in general, this is how it goes. And then once something's expunged, so once it's ordered, all agencies with that information that have record of this case have 60 days to remove and destroy the record. So you wait the 30 days for, see if someone objects, wait a little bit longer for the judge to actually sign off on it. And then that order is sent out to whoever filed, and then anyone who has record of it. So the police department, the state's attorney's office, CJIS, whoever it might be, anyone. And there's a whole list, and they have a whole checklist of everyone it gets sent to. And once they receive it, they have 60 days to comply with that order. And once they do, then you receive something called a certificate of compliance in the mail, which is them indicating that they did comply with that order for expungement and remove the record. And these records at this point should no longer be available on case search. If you got your fingerprints done at this point, it shouldn't be coming up on there at all. I do want to say this is only for Maryland. This is a Maryland law. We're only talking about Maryland records. So even though this applies to Maryland, if you got a very in-depth FBI background check or another state potentially, or you're doing a public record check on a private company site or something, it may come up on there. We can only control it. Maryland courts can only require that they remove it from, what they have jurisdiction over. But usually there's a lot of places. In some cases, it'll come up on your federal background check. You can send them a copy of the expungement order and request that they remove it, but they're not bound to, unfortunately. And at this point, once it's been expunged, you've gotten that order, and always hold on to your orders because it's going to be the last record of that case. You at that point in the state of Maryland are not going to be required to disclose anything about that case that's been expunged to an employer, licensing agency, education institute, anything. You don't really have to talk about it. You don't have to say it happened. That being said, though, if you're doing a federal background check or something, not in Maryland, you might not be able to say that. So it's a little trickier on that. But for most people, once it's gone in the state that they live in, it's really not much of an issue anymore. I do say be careful with immigration issues on here, because if you are not a citizen, if you're a green card holder or you don't have a green card, whatever your citizenship status is, even if you have it expunged, it's still something you would have to say on your immigration paperwork. My husband just got his citizenship a year or two ago at this point, and they don't care if something's been expunged or not. You need to just tell them everything, unfortunately. So, and Maryland Legal Aid, unfortunately, we do not do expungements for non-citizens because we want that person to consult with an immigration attorney just to make sure that we're not jeopardizing any status. That doesn't mean that people that aren't citizens shouldn't get expungements. It just means that you need to do a little extra due diligence on it to make sure that, for one, they're aware of how this can affect their immigration status and what they need to disclose. So that's basically it. I just want to go over a few common issues that we see a lot of. And again, I say if you're ever doing any of these, please, again, I'll give you my information. Please reach out. We just do a lot of them here. It's the majority of the work that we do. And there are all these weird little issues that pop up that can be confusing or can cause issues. And there aren't a lot of people doing expungements, at least not a ton of them. Though you find a private attorney that does one or two here and there, but they're not quite sure about all the nuances. So I really encourage anyone to reach out. I'm happy to talk about it anytime. But kind of common issues we see that I just want to address very quickly here. Violation of probation. So you were found guilty. I'm going to say you're found guilty of theft under $100. So that's one of your misdemeanor convictions that can be eligible after the 10 years with no subsequent convictions. But on there, you received a guilty on your violation of probation. So on case search or other documents, it might say, charge 1, theft under $100, guilty. And then under that, it says, charge 2, violation of probation, guilty. Some people like to say that means that the whole case is ineligible because a violation of probation isn't a guilty that is listed in 10110 isn't listed in the statute as eligible. This is not correct. You can have something expunged if you were found guilty of a probation violation on that case. This is because for a violation of probation, it's not technically criminal. So in a probation violation hearing, it's a lower standard of guilt. It's not, beyond a reasonable doubt. It's a lower standard. Technically, it's civil. It gets a little tricky. I'm not a criminal attorney. I'm not going to get into it too much. But the thing is there, that one case I talked about, Robert B.V. State, it's basically the case we use all the time. It's very clear in there that a violation of probation has been found to not be a criminal issue. It's related, but it doesn't count as another conviction. That's from the Supreme Court, from the highest courts in Maryland, all of that. So if you have someone who has a guilty of violation of probation, but the underlying charge is eligible for expungement at this point, you can file that. You might get an objection. I have in the past, but I've never lost in court on it. Another big one you see a lot is fugitive warrants. So a fugitive warrant would be something like you have an arrest warrant for you in Virginia, and you're picked up in Maryland, arrested in Maryland, held, and then transferred to Virginia or whatever state. That comes up on case search around records as a fugitive warrant, whatever it is. These are not listed anywhere as eligible for expungement. So those we can't have removed. This is something that gets brought up to the legislature when people are testifying about expungement. And I really have a lot of hope that this will change, but I see this a lot and I get a lot of questions. If you have a fugitive warrant that is not eligible for expungement. So probation before judgment for marijuana possession. This is one that drives me absolutely nuts, and it doesn't make a lot of sense, and it kind of goes in line with what I was talking about with like the expungement laws they weren't written perfectly. So if you were found guilty of possession of marijuana of personal use, like we talked about, it's that 4-year waiting period with no subsequent conviction rules. You just got to wait that 4 years, and then it's eligible for expungement. Now, if you received a probation for judgment for that marijuana possession, it's that 3-year waiting period, but there is a subsequent conviction rule. The issue here then is you should have taken the guilty, right? Like, so the probation for judgment is a lesser penalty, but actually your guilty can come off and your probation before judgment can't because of the subsequent conviction rule. I personally file these if you have a probation before judgment for possession of marijuana, even if you have a subsequent conviction that would lock in any other type of probation before judgment. I file them. I think we all do here at Legal Aid. And it's a toss-up. We've won in court and we've lost in court on it because the language in the statute is quite clear that does not talk about reasonable judgment for marijuana possession. And so if a judge is really reading, doing black letter of the law kind of thing, it isn't technically eligible. There's a very good argument that it was an oversight of the legislature and legislative intent and all of that stuff. And sometimes we won on it. But that is, a concern, and it's something important to point out. Another thing we see a lot of is minor traffic cases that used to be incarcerable. So like I talked about, running a stop sign, if you got a guilty for doing that, that was never incarcerable. No one was ever in the state of Maryland should have been facing any incarceration, any jail time for running a stop sign or any of these minor traffic cases. But sometimes the law changes. So driving without a license is one of those cases that is not eligible if you're convicted. It is a serious traffic case and it's not listed in there. And this starts invoking your unit rule. So if you had a minor traffic case and an incarcerable traffic case, we ignore that minor traffic. And even if it was a guilty, it's not invoking the unit rule, it's exempt. But what happens when the law changes? So something used to be incarcerable. It used to invoke the unit rule. And now the legislature has changed it and said, no, that traffic citation isn't incarcerable anymore. Now that's only a monetary penalty. This gets very confusing because then we want to say, well, this doesn't invoke the unit rule. We're going to ignore it if someone received a guilty on that now minor traffic. And the courts, no one agrees on this. We file them, but it can be very tricky because we'll say, that guilty, that's minor traffic now. And the court will say, well, it wasn't minor when they received it. Then you get this whole argument if it's retroactive or not, and legislative intent, and all these things. So be careful with those. There's not a ton of them. The big one you're going to see is a 16303H violation. It's one of the driving without a license. There's a bunch of them. 16303H. If you see that one, it may cause a problem depending on if it was a guilty or not and if the unit rule is invoked. And this last one is identity theft and fingerprint issues. So when you file for expungement, and again, we'll go over the petition shortly, you sign, it's basically an affidavit, someone signs it saying, I was found not guilty, I don't have any open cases right now, this is me, I am, and signs off on it. But what happens is when the state's attorney has their time to object, the police department does a check as well. And sometimes they will bounce it back and say, the fingerprints for this person doesn't match, whoever signed this paperwork. And this I see too often. And it's always someone's cousin or friend or someone who used their ID and got arrested or got a citation using someone else's ID. And for whatever reason, the court record remains with whoever ID that was. So let's say it was me. It says Mariel Shutinya did it, but really it was my sister Robin. So I filed for expungement, it's on my record, I filed to have it taken off. This could be because I had kind of a lengthy record and I didn't realize it wasn't me, or you just want to have it removed and you don't know where the other person is, whatever it is. You file for expungement on that case. The police department comes back and says, oh, no, the fingerprints don't match that name. It matches, Robin. It's not Mariel, actually. And since Mariel's the one asking for it expunged, we can't do that because you have to be the actual defendant. So it seems like, well, it's eligible for expungement. It's under your name. You ask, why won't the court grant it? But they won't. And they won't do anything about it either. So then it just stays there under the wrong person's name, but not able to be expunged because of, this identity theft issue. If you see this, if you have this, please reach out to me about it. We have gotten around it with special motions, explaining all of this and asking them to shield it or change the name. We have been successful, but it took a very long time and had to be done with cooperation of the state's attorney's office and joint motions and things like that. So when I get too into it, but it's an important one to know because it happens more often than you would think, where people are victims of identity theft and there are charges that they, that weren't them, but come up under their name. So that's it for this portion. And then I think we can take some questions now, and then I'll just show everyone kind of those cheat sheets I had and then how to fill out the form specifically. But again, here's my contact information. Again, I'm in the Community Lawyering Initiative. That is my direct phone number, 410-951-7711. I'm the only person who checks that voicemail. And then there's my email address, which is mshutinya@mdlab.org. And I'm looking at the chat. Let me see if there's any questions. So Matt asked if legally to try to get access to CJIS. We're trying all these different things. And since we're not a state agency, we're running into some problems. But any creative solutions on getting us access to anything, we are happy to hear about because we are in the process of kind of dealing with this. And yes, someone pointed out that there is a form for pro se individuals to request a fee waiver for hardship that's available on the court website. We don't use those because we have that other one. And just so you know, if you do a fee waiver, you usually have to, fill out information about your finances, and then you want to attach some supporting documents to back it up as well. It doesn't say that on the form, so I always like to point that out that you will need to include some documentation. So yes, I can provide the PowerPoint afterwards. Those are the two questions. Easy ones. Thank you for that, guys. So if there are no more questions on this right now, I'm going to switch my screen and go over how to fill out those petitions. Again, I know it's going to seem really repetitive that we're going to go through it line by line, but for one, the court will reject it or the state's attorney will object if it's filled out incorrectly. And also it is a nice way to kind of reiterate what we talked about because the form typically explains a lot of these things again. And the other thing is I have attorneys all the time at Legal Aid that will reach out to me because we do so much expungement, and they just didn't read the form, and you're just checking off boxes and haven't actually gone through it. So it's important to read through it. And again, I encourage anyone to read through Criminal Procedure 10-101 through 10-111. It's not very long, and it kind of reinforces this information, and it's good to know. So let me move to this PDF if I can find it. All right. And then, so first off, I hope everyone can see this okay. I apologize. It's just this PDF. I tried to integrate it into the PowerPoint, but we do not have the most up-to-date Microsoft at Legal Aid as a nonprofit, so it didn't work too well. So we're going to do it this way. This is actually, I want to put this one out there, and I will send this to everyone to make sure everyone has a copy of it because it's really, really helpful. This is my expungement flowchart. And I have to say it is like my proudest moment of anything I've ever done as a lawyer, because I am not visual. I'm not good at things like this, but this is really, really helpful. So I went through all those rules, and this flowchart can just help you. You can just run your finger down it and get the answers you need on it pretty quickly. So what you do is you look at all the charges in a case, trying to figure out if it's eligible or not. And I always say you start with the most severe disposition. So you're guilty, your PBJ, your stat, whatever it is, start with your highest one, because if that one isn't eligible for expungement, none of the other ones will be either because of the unit rule. And what you can do is just go down and say, oh, it was a guilty on a nuisance crime, say more than 3 years has passed. No, it's not eligible yet. More than 3 years, yes, eligible. And it goes through it like this. And again, I'll send this to everyone. I think it's really, really helpful for visual learners, or just so you don't have to remember everything as much. Also, I'm just very proud of it. So I think everyone should use it. It's really useful. The other thing, before we go over the petitions, I will provide this out to everyone as well. This is a list of the serious traffic offenses. So those minor ones, I said ignore. Everything, if it's not on this list, then you can ignore it. It's going to be minor. This is a list of all the incarcerable traffics. I do have to say, please ignore this penalty location portion. All traffic penalties used to be listed in the transportation article 27-101, moving forward. And they changed that a couple of years ago. And most of the penalties are now listed in the same section as the violation. That being said, this is a pretty up-to-date list on what is incarcerable serious traffic and what's not. So if you find a traffic citation someone has, and it says it's a 16113J, violation of alcohol restriction, that's going to be incarcerable. So it may or may not be eligible for expungement depending on that disposition. So this is really helpful. You don't need to memorize all of them. You don't need to go through the statutes all the time. And I'll make sure everyone gets a copy of this. If you do enough like I do, I kind of unfortunately have them all memorized, but this is really, really helpful for everyone, and I'll make sure everyone gets a copy of it. And then this is a list of all of the misdemeanors and felonies that are eligible for expungement under 10-110 as well. So again, once you start doing a lot of these, you'll start to see what's eligible and what's not pretty quickly. Because the ones you see all the time are going to be theft, prostitution, possession, trespassing, things like that. But then there's these really random ones. Discriminatory real estate practices in Montgomery County prohibited. Shouldn't be doing that, but I don't know why that one got listed in here. They just are very random. And so it's kind of hard to know what is eligible, what's not, when it's not one of the common ones. This list is really helpful. It's done by statute code. And I'll send this out as well. And this is the most up-to-date one. This is from March of this year. And this includes the felonies at the bottom as well, and the specific code that you would use. So I'll make sure everyone gets copies of that. And now I want to go over the petitions with everyone, because these are unique looking. And if you don't fill them out correctly, it could cause either delays or denials. So first off, what you do, like I said, you have to file in the highest court it was in, and you need to file it in the jurisdiction that the case was heard. So if you had a case that you want expunged and it was in Baltimore City Circuit Court, you fill out Circuit Court, you click it, or district, whichever one it is, and then you can scroll down and find it. I'm just going to be making these up, but just so everyone can kind of have a good idea of how these go without breaching any client confidentiality by using a real case. Put in the court address, Baltimore City Circuit Court, you just have to look it up. For Baltimore City District Court, which gets the most expungements filed in it, is always the Wabash Courthouse. There are multiple courthouses in Baltimore City. If it's a district court case, your expungement is going to be at the Wabash Courthouse, 5800 Wabash Avenue. But again, you can look this up online. I just Google it. It's listed on the case, depending. You type in the case number, so whatever case is listed. And then there's something, a tracking number. This is different. Tracking number is a 12-digit tracking number that's usually associated with the arrest. Not all cases have tracking numbers, but if it does, you want to put it there. It allows the court to find it more easily. For case number, so if you file in district court, you're just going to put that district court case number here. If you file in circuit court, you want to put the circuit court number, and then you also want to put the district court number if that happens. So like I said, a lot of times you'll be charged in district court, a district court number is given to that case, and then you request a jury trial or something else happens, and then that case moves up to circuit court. We try to include all associated case numbers on here, so it makes it as easy as possible for the court to find it and expunge it for you later. But again, if that happens, you still want to file in the circuit court, always in the highest court it went to. And then here you put the defendant's name. If someone has changed their name since they were charged with this crime, you see a lot of time with women that have changed their name or whatever it might be, I always leave it as the name the person was charged with. So it matches the court record completely. You don't want any reason for them to think that something's off or that it's not the correct person or to cause any confusion. If the person has changed their name at the bottom when they sign, I have them sign their legal name and then put in little parentheses, whatever the charging name was, just so it can be very clear that this person's name has changed, but they are still this person. It's going to refer to the individual filing for expungement as the defendant. We refer to them as the petitioner because you're petitioning the court for this. And I don't believe you're a defendant anymore because the case is over, you are the petitioner. So I'll use them, I'm gonna say petitioner if there's any confusion around that, but I do think it's the appropriate term to use. So this is Form A, and this is the form you use for the non-convictions. So it's your acquittal, dismissal, probation before judgment, null pros, stet, the not criminally responsible, and the transfer to juvenile court. The guilty one we'll go over. It looks pretty similar, has different options, and we'll go over those just so you can see. But if it's a non-conviction, you're going to use Court Form A, this one. And I'll make sure everyone gets copies of this as well. It's on the court website. You can just Google expungement form, but you can always use this as well. And on here, it explains like what is eligible and what isn't. It has to be reference to crime, criminal action, civil offense or infraction. And then it talks about the traffic laws that, carry the possible sentence of imprisonment or not. And so what you do is you have to put the date the person was arrested, served with a summons, or served with a citation, and you have to check off the box. So if you were arrested, January 1st, 2021, that's what you put in here, you were arrested. Sometimes it's tricky to determine if someone was arrested or served a summons or a citation. You want to get this correct. Sometimes you have to call the court to ask. Sometimes the client will know, but this does need to be filled out properly. And then you are served with a citation by an officer, and you need to put the correct police department or law enforcement agency. So this would be BPD. Usually if it's Baltimore City, it's going to be BPD. But other places, it could be, we always see like a small little city, the Salisbury Police Department versus the county, things like that. So you need to get the correct law enforcement agency. This is one where they really do check it quite well, and you're going to have to make sure it is correct. This is mainly because when they're asking for once it's ordered, they have to know which police department to send the information to have it expunged. And I apologize, you also need the person's date of birth up here. Again, if it's wrong on the case record, I will put the incorrect one in, just so it's consistent. That doesn't happen very often. but you want to keep it as consistent as possible if you can with the court record, so there's no questions. So you say, served a citation or arrested by the Baltimore City Police Department at, and then you just put the jurisdiction in again, Baltimore, Maryland, whatever it is, as a result of the following incident. Let's say this was a possession of marijuana. You just write that in. I know that sounds silly because it doesn't really follow incident possession of marijuana, but that's what works and it's fine. And then I was charged with the offense of, and again, let's say it was possession of marijuana. But let's say you have 3 charges on there: possession of marijuana, possession of paraphernalia, and theft, let's say. And you can't fit all of that on there. I always add an addendum. And so, just an additional piece of paper that you can type up. They don't include one. And you'll write charge 1, possession of marijuana on the addendum, charge 2, possession of paraphernalia, charge 3, theft. Because you need to list out all the charges on here for them. It can get a little annoying, but it's just good. Again, it's just to be as complete as possible so everyone knows exactly what's requesting to be expunged. And this is pretty important too. So you have the date you were arrested. It doesn't need to be exact, it's on or about, but you want it as close as possible. And then you want to put the date that disposition was received. Because like I said, on these favorables, it's always very important to note the disposition date, because that's when the waiting period starts usually. Let's say, today I received A2 2021, I received whatever, the disposition was finally entered on this date. And then you go down and you have to check off which one it is. And, we'll go through them very quickly, but it's important to read through all of them. So this, I was acquitted, right? I was found not guilty. And then 3 years have passed since the acquittal, or that general waiver and release is attached. And I'll show you guys that in a second as well. So if I was acquitted of this charge or all these charges, that's what I'm going to put. If you have more than one disposition, you were acquitted on the possession of marijuana and the other 2 charges were dismissed, you can check both of them, whatever it is. So on these, sometimes you'll have multiple boxes checked if there were multiple dispositions. On the guilty form, which we'll go over, if you were found guilty and then you had null process on that too, don't worry about it. For those, you're just going to check the guilty. But for these, you just check off as many as are applicable. So dismissed or squashed, again, it's this 3 years have passed, or you have the general waiver. So it's a good reminder of what you need to do. A probation before judgment was entered, but the conduct on the charge base is no longer a crime. This would be that possession of marijuana less than 10 grams. You received a PBJ on that, but it's not a crime anymore. You check that box and you don't have to do that waiting period then, right? That 3 years. And this is different than just a straight up possession of marijuana possession PBJ, because that is still technically a crime. And so you can't check that box and it turns into a whole thing. So then this one's really important, the probation before judgment. If that was the disposition, it was entered and the conduct is still a crime. And then the charge should not allege a violation of transportation article and list all this stuff out. These are going to be those DUIs, and those that are the DUI PBJ, I said was the only PBJ that's not allowed off. That's what that's referring to. And here, either 3 years have passed since the disposition, or you've been discharged from probation, whichever is later. Again, it's usually 3 years, but if you had a probation longer than that, you have to wait until the end. This gets very tricky for prosecutors and the court. We always joke that they're just not very good at time math. So sometimes you'll get an objection saying, oh no, you have to wait 3 years from the end of the probation. And that is not what it is. It is 3 years from the disposition date or the end of the probation, whichever one's longer. So sometimes you will have to go to a hearing over that. They're usually not too difficult to win at, but it is frustrating and it's difficult because clients a lot of times can't make it to hearings for whatever reason. I do have to say, if you are representing someone on an expungement and they are unable to come to court, majority of times we are able to represent them without them there. Some judges like to give us a hard time for that, but typically we can waive someone's appearance. Like I said, those 3 years have passed, or probation, whichever one is longer. And then, except for any conviction of a charge where the conduct of that charge is based on or calling, I was not convicted of any crime during the 3 year period immediately following the entry of probation before a judgment. I am not now a defendant in a pending criminal action. So that's the I don't have a pending case and I don't have a subsequent conviction. And then for a null pros, which is a very common one, 3 years have passed, you have your general waiver and release, and you're not a defendant in a pending criminal action. So again, there's no subsequent conviction rule there, but you still can't have a pending criminal case. A stat, again, it's 3 years have passed and I'm not a defendant in a pending criminal action. So you got to wait your full 3 years, but no subsequent conviction rule. I was found not criminally responsible for a crime specified in 10-105, and those are listed out if you look at that article, and then 3 years have passed since then. Again, no subsequent conviction rule. I've never seen either of these compromised or not criminally responsible, but there are boxes for it. This one, you see a decent amount. The case was transferred to juvenile court, and it's saying the court, this petition must be filed in the court that issued the transfer. You're not going to file in the juvenile court. And it's only going to be the record of the case, not the juvenile case. It's more just so that's not out there anymore. And then the case began in one court and was transferred to another that was not juvenile court. So in this case, like I said, if this was a circuit court case, it started in district court and then got transferred to circuit court. You're filing in the circuit court because it's the highest court that heard it. You check this box also. And that again is letting them know that there's a district court case that's going to have to be expunged as well. So when the circuit court orders the circuit court orders this circuit court case to be expunged, they will send the order of expungement to the district court as well, along with the police department and everyone else, telling them to expunge the record. And then at the end, you're saying, I am requesting to enter an order for expungement for all of these records. And then you have to sign here. And this is saying that, it's all under the penalty of perjury, that, this is me, it's not for any non-incarcerable violation of the vehicle laws. So it's saying that it is criminal, not minor traffic, and that you're, under the penalty of perjury, saying that you're not a defendant in a criminal case right now, that you didn't have any subsequent convictions, whatever it might be, that it is you signing this and it was you who was charged with this crime. And that's where that identity theft stuff comes in. Now, if I'm filing on behalf of a client, I need to fill this out and sign it as well. And the defendant, again, what I would call the petitioner, the client, has to sign as well and fill this out. So this part, the one with the defendant, this portion, always needs to be filled out. It has to be the person who's requesting it, who the case is about. They're always going to have to sign it and provide their information. If an attorney is representing them, or if you're an attorney and you're helping someone do it, then you would need to fill out this portion as well. But if someone's doing it per se, or you're helping them, but you're not an attorney, whatever it might be, you can leave this one blank, as long as this one is filled out. So that is how that first form looks, and it's going to be very similar to the guilty one. So I'm going to go over this one a little faster, but I just want you to see it, just so kind of everyone has a good sense of what's going on. I think it's a little easier when I ramble at you about all the rules, and then to actually see how it gets filed with the court. So again, you pick whichever court, the highest court that heard it, pick your city or county, you put the court address, the case number, the tracking number if you have one, your defendant's name, petitioner's name, and the date of birth. And then it gets a little different. So this is only for guilties. And you're going to do like you did before, on or about this date, the person was arrested, served with a summons or citation, click the right box, an officer of whatever law enforcement agency at whatever jurisdiction. So again, if it's Baltimore Police Department, it's going to be at Baltimore, Maryland, as a result of a following incident, whatever, I just put the first charge 1, that's what you list right there. And I was charged with the offense of, and then you list out your first charge. And if there's more than one charge in the case, you're going to put the addendum and write all of them out there if you can't fit them all in this box. And then on or about the disposition date, the date the person was found guilty, you put that here. And then this is where it gets a little different than the last one. So first, the charge, I was convicted of the charge, but the conduct on the charge was based is no longer a crime. That's going to be your possession of marijuana less than 10 grams, or anything else that is no longer criminal. A crime specified in Criminal Procedure Article 10-105, this is going to be your nuisance crimes. 3 years have passed since the Since the later of the conviction or the satisfactory completion of the sentence, including probation, I'm not a defendant in any pending criminal matter or action. And so it's that 3-year waiting period. If you've received a probation that was longer than that, or a sentence longer than 3 years, you have to wait for it over. Then you can't file for expungement for something where you're still being penalized for it. But again, I've never seen that. If you get a citation for eating on the subway, you're probably not going to get a 4-year penalty for that. But that's the nuisance crime one. Possession of marijuana under criminal law 5601. This is going to be that more than 10 grams, but less than a distribution amount. 4 years have passed, so it's in that 4-year waiting period, and I'm not now defendant in any pending criminal action. So you don't have an open case, you've waited the full 4 years, but again, no subsequent conviction rule there. Like the same as for the nuisance crime, no subsequent conviction rule. Now this one criminal act, which is not a crime of violence, and on or about, and this is a pardon one. So if someone received that full unconditional pardon by the governor within the last 10 years, so if someone didn't realize they needed to file for expungement and they received their pardon 12 years ago, technically you're not allowed to have it expunged. I've never seen that. I feel like it could be argued. I would still file it, to be honest. Maybe make a little note on here, but I would still file it because it's kind of a silly rule. And, we've never had it happen. If you do have this issue, feel free to reach out and see if we can help in any way on it, but it's a pretty rare circumstance. And again, you cannot be a defendant in any pending criminal action, but no subsequent conviction rule on that. Now, this is all of the misdemeanors we talked about. A misdemeanor crime specified in Criminal Procedure 10.110, 10 years have passed since the satisfactory completion of the sentence. It's parole, probation, supervision, whatever it is. Sometimes they like to parse satisfactory. So sometimes they'll try to argue that a violation of parole would cause it to not be a satisfactory completion. This satisfactory completion language is on here, but it's not actually in the statute the same way. And the statute's what's controlling, not the form. And so I've had to have this argument many times, but again, we've never lost on it. But basically, if the state no longer is punishing you, no longer has any control to impose any punishment for the crime that you were convicted of, that's when your waiting period starts, 10 years from that. Then since that date I have of conviction, I've not been convicted of another crime, not now eligible for expungement. This is a really important point. Sometimes the state's attorney will object and they will say, well, there's a subsequent conviction on here. And that subsequent conviction needs to be expunged first before this previous one can. And the law doesn't say that. The law says that it's not now eligible for expungement. So when your subsequent conviction becomes eligible, all of them can come off. You don't have to file that one first, wait for that to expunge, and then go down the line. They can all be filed at the same time because it's about eligibility, not actual expungement. This is something that comes up in hearings sometimes. It's a little frustrating. You're just trying to get them to read the law properly. Again, we've never lost on that, but it's worth noting that that could be an issue. Then you've got the felony one. So again, it's going to be that 15-year waiting period from the end of the sentence date. You haven't been convicted of a new crime, not now eligible, and you're not a defendant in any pending criminal action. So no open cases and no subsequent convictions. This one is crime specified in Criminal Law Article 3203. This is going to be your second-degree assault. So this is that 15-year waiting period, even though it's a misdemeanor. So it's its own box. So it's really important to know that so you check off the right one. Again, you have not been convicted of a crime not now eligible, so no subsequent convictions that aren't eligible themselves, and no pending criminal action. And then you've got these same two that we had on the last one. The court was transferred to another court other than juvenile court. So again, you might check this box in addition to other ones because it went from district to circuit, found guilty in circuit. It meets one of the other boxes, but you also want to, again, indicate to them that this case, they need to send this order to the district court as well, or whatever lower court. Or the case was appealed to a court exercising appellate jurisdiction, and it must be found in that appellate court. And I've never done one of those. I haven't seen it, But in the case if someone appealed to this Court of Special Appeals or the Court of Appeals, depending on what it was, you're going to have to file in the highest court. And then like the last one, there's this, penalty of perjury. You're signing, saying that you're complying, all of this is accurate. And if you are pro se, someone's doing it by themselves, just fill out this portion. And then if an attorney is filing on their behalf, you're going to fill out this one as well. And again, this is that little thing down here that if it's a conviction, victims have the right to offer objections. And that person would submit this to the court and let them know. And the court has to take action as soon as 30 days after the petition is served. So this is just saying that the victims have a right to object only in cases where there is a conviction, not in those favorable dispositions, not in any of the other types. So those are the forms. And let me see, to show you one more. The general waiver and release I was talking about. This is again for those not guilties, null process, on dismissals, where it happened within the last 3 years. So you have to sign that the person has to sign the general waiver and release to say they're not going to sue anyone related to it in order to have it expunged within the 3-year period. So you fill all of it out like you would other parts. Whatever court it's being filed in is going to be the same as the petition, that information, case number. And then you're going to put the petitioner's information, the defendant, and then, fill out their address and their contact information. And here you put the defendant or the petitioner's name, who's ever asking for this to be removed. So if it was me, I'm looking for my case to be expunged, I put my name in, and then you have to put the complainant's name. And this is where it gets a little tricky because sometimes you don't know who the complainant was. So if there's a victim, it could be them. It'd be whoever complained, whoever filed the police report. Many times the complainant is just going to be the arresting officer. So you can usually find that on case search. You can call over to the court for it. The person might know, but you do have to list them explicitly. So let's say my sister accused me of stealing from her, I'll put her in here. And then you also have to put that law enforcement agency. So Baltimore Police Department is who I said arrested me and put on the petition. They go here as well. And you're just saying that you're releasing and forever discharging all of its officers, agents, and employees, and all other persons from any and all claims that may for wrongful conduct by reason of my arrest, detention, or confinement on or about, and you want to put the arrest date. Like I said in that other one, I was arrested on January 1st of this year. It's not disposition, it's that arrest date or whenever you were confined. And then you're just saying here that this general waive and release is conditioned on the expungement of the record, and it'll be void if the conditions aren't met. So if they end up not expunging it, you're not going to be held to this anymore. And here you have to put the date you sign it. So, this is me, I'm signing it August 2nd day. I would sign here, or whoever the defendant is, and then someone needs to witness it. So when I'm doing expungement petitions for a client, I witness it and they signed, and that's good enough. If someone's doing it pro se, the defendant or the petitioner would sign here, whoever's asking for the record to be expunged, and then they would need someone else to witness it, and that person would sign and handwrite their name. And that is it. That is what a general waive and release looks like. So that's pretty much it for now for me. If anyone has any questions about any of that, I'm happy to answer them now. And then I also make sure to get all of those documents and the PowerPoint slides over to Aman or Matt, just to make sure I can get everyone copies of it. And I'll include again the flow chart, the list of all of the serious traffic, the list of misdemeanors that are eligible, all of those things, everything I just showed you, I'll include to make it as easy as possible. So anyone have any questions? So I see a question that says, can you get a case expunged if you plead guilty? Yes, definitely. So it doesn't matter how you got that guilty disposition. If you were found guilty at a hearing, if you did a plea bargain, it doesn't really matter how you got to that point. If you plead guilty and the disposition is a guilty, it's eligible like any other one. If you pled guilty, like in a probation before judgment, so it says plea is guilty, the disposition is probation before judgment, we're not ever worried about what you said, what you pled. It's all about what that disposition is. I have had state's attorneys try to say that a probation before judgment is technically guilty because you pled guilty, but that's not how the law is, and that doesn't make a lot of sense, right? It's about what that disposition was. That's what we're going to pay attention to. So it doesn't matter if you plead or if you're found guilty or whatever it is. It's all about, if it's a guilty disposition and it's one of those eligible guilties, it could, it could be eligible for expungement. All right, anyone else?
I think we have a raised hand.
Okay. How do
Hold on, Latasha, let me see, I can allow you can speak if you want to just ask your question.
That was actually my question there, about the guilty plea.
Okay, perfect.
Sorry about that.
Did that make sense, my answer?
Yes.
Okay, cool.
I've heard in the past that if you pled guilty, you can't get it expunged.
And so there's a lot of, I wouldn't call it misinformation. I would say that because the expungement laws have changed very recently, there's some outdated information out there, because it's true if, it's not about pleading or not, but 4 or 5 years ago, most guilties couldn't come off your record. They weren't eligible. So it's really important to kind of keep putting this information out there, because who's really keeping up with all the little changes in the law? But so many things are eligible now that didn't used to be.
Thank you.
Thank you. Anybody else? All right.
So thank you so much, Mariel. I just want to again say, our intentions behind this is to expand capacity to help organizations that do this work. So BALT will be in contact with you again to see if you all, if interested, will sign up for just 1 4-hour shift per month to help some of our community partners. And again, Mariel, I think this is very informative, and I just thank you for helping us and supporting us.
Oh, thank you so much. We absolutely love all the work y'all do. And, any questions about expungements, again, I'll include the PowerPoint. I'll have my contact information. Please, anyone reach out at any time. Always happy to help and, provide any more resources we can.
All right. Well, thank you, everyone. Have a great Monday.
Thank you. Come on, can I send you all the papers? Is that okay?
You sure can.
Thank you so much.
Where's the recording?